especially, have been lawyer driven, meaning it's the lawyers who gets to drive the case by setting up their CMOs and experts and things like that. Yeah, how can I get rid of this screen again? It's got it. And to leave. So what I mean by that is we've let the lawyers drive the cases for some unknown reason. The Supreme Court doesn't like that. They want us to drive the cases, and the rules are different when we drive cases versus you all. So I'm sorry to bring you the bad news on that, but that's what they wanted. That's the rules they approved, and that's the rules we're all going to have to live by into the future. And I'm going to show you at the very end of this PowerPoint, at least from Broward's standpoint, why that seems not necessarily a good thing. Okay, the first thing on these cases, especially business cases, there are certain exemptions that don't apply. The ones that are significant for business would be maybe administrative proceedings at the end, property foreclosures, arbitration enforcement, extraordinary writs, enforcement of foreign judgments, and administrative summons. None of those require the case management that we're going to be talking about in these slides. Also, confirming a foreign judgment. Now, the one that says cases in a special division by AO, our two complex divisions are in an AO that I have assigned year after year after year. But myself and Judge Phillips, to avoid confusion, are going to have all of these new rules apply to complex business and complex tort. And therefore, you're going to have to live by the same rules everybody else does in the courthouse on civil cases. Okay, we all know this rule. Complex cases are governed by 1.201. And I would encourage you all, when you read the orders that I've handed out here in the courtroom and the ones we're going to post on our website, see if you see any potential conflicts in what I've written in our suggested CMO and what's in those rules. I think I may have placed the mandatory requirements in different places in the complex order. So double check me on that. I think I did see one typo also. Okay, in general, now I'm going to talk to you all in terms of not every case you all have is in my division in complex business. You also have you also have cases in general circuit divisions, which are governed by the same kind of trial order, CMO and trial order that you're going to see here. This order must also set deadlines. Is there a way? I can't get rid of that panel on my right side here. The order must also set deadlines that differentiate whether the case is streamlined or general. This order must specify the following deadlines. I'm going to go over those in more detail. Case management order must indicate that the deadlines established in the order will be strictly enforced, and it does. And there's another category in a CMO that says deadlines in a CMO are strictly enforced unless changed by the court, which means despite the fact that us having a portal to send in agreed orders, if your agreed order conflicts with the CMO and the judge inadvertently signs it, CMO is going to control the order he signed, she signed. Not going to make any difference unless you have the judge's permission. Parties may submit an agreed order to extend a deadline if the extension does not affect the ability to comply with the remaining dates in the CMO. That's something only you all can judge. If extending an individual CMO deadline may affect a subsequent deadline in the CMO, parties must seek an amendment of the case management order rather than submitting a motion for extension of an individual deadline. You guys need to read these things. I'm telling you right now, they are very specific and they are very judicial driven. So you must presume that because your CMO is going to come from me at some later time, that these rules are going to be enforced by me. And I'm going to talk about that too before we end today. Okay, preparations required. And this is something that I think you lawyers with larger law firms better get on board with right away. I don't know what to do, you lawyers who are in a law firm by yourself. And attorneys and self-represented litigants who appear at a case management conference must be prepared on the pending matters in the case and be prepared to make decisions about future progress and conduct of the case, I guess. I can't see the last two words. And have authority to make representations to the court, enter into binding agreements concerning motions, issues, and scheduling. A party is represented by more than one attorney. The attorney present at a case management conference must be prepared with all attorneys. So you need to prepare your attorney, because if the judge says, I'm going to take up a motion or I'm going to rule on something, and your lawyer is not there, or the chief lawyer is not there, and the judge says he's going to do it, he's going to do it. And if you all say, Judge, Joe Schmo was out in California, judge is going to say, sorry, don't care. Look, this is what the Supreme Court wants. It's not what I want. Okay, so all of you look at me with these mystifying looks at something that we've never done before. It's what's going to happen. And we're really going to have to, from the 17th, I guess every circuit throughout the state is going to have to decide how hardcore they're going to be about the enforcement of these rules. It doesn't say in here mandatory more than 400 times because it's optional. It says mandatory because it's mandatory. And you all need to learn these rules. It took me 43 years to learn the rules of procedure. Now I got to learn them all over again because these rules are just quite different. On failure of a party to attend a case management conference, the court may dismiss the case, strike the pleadings, limit proof or witnesses, or take any other appropriate action against a party failing to attend. That is completely, totally contrary to the existing precedent in the 4th District Court of Appeal. So how the 4th District is going to treat these rules in relation to their own case law is yet to be seen. But they're no different than us. They have to follow the rules from the Supreme Court. There's something called, I think it's called Cozen factors or something like that, where you have to make specific findings about prejudice, willful disobedience of a court order when you don't attend something like a case management conference, or used to be in the old days when everybody had calendar calls. And if people didn't attend, Judge Creighton was great at this. He used to dismiss the case. He'd make no findings. He'd get reversed, or some of the cases would just go away. But now this is completely different than the precedent that exists in the 4th District. Supreme Court has rulemaking authority over the 4th. So we'll see how that all plays out in the future. Okay, here are some of the most important parts of this. In general, a party must, without waiving a discovery request. What's that mean? You don't have to sit around for them to send you interrogatories, request to produce, request for admissions, without waiving a discovery request pursuant to the other parties, but must provide to the other parties the following initial discovery: name, address, telephone number, email address of each individual likely to have discoverable information, together with the subjects of that information that the disclosing party may use to support its claims or defenses, unless it would be solely for impeachment. The last sentence in my mind is going to have very minimal attachment to this, because most of the time you don't know what your impeachment evidence is until you get close to trial. So that's without making any request. That is your burden, both plaintiff and defendant. And then you need to provide also a copy of, by category or location, all documents, electronically stored information, and other tangible things that the disclosing party has in its possession, custody, or control. If you represent somebody, and even if it's IBM, you have control over their discovery because you are their lawyer. And giving the idea that, well, some bureaucrat said it's in such and such and such is no longer an excuse and no longer a defense. Or if not in the disclosing party's possession, custody, or control, look at that one. A description by category of and location of such information. Well, if you don't have it, where is it? You know you're going to use it eventually, and you don't have it, you don't disclose it. The likelihood is that evidence will be stricken by the judge. So you better be really careful about how you answer these things, and may use to support his claims or defenses, unless, again, solely for impeachment. So if you've got defenses that are being supported by documents, ESI, or other things, you better find out where they are. If you don't have them, well, I would strongly suggest you get them, so they're in your possession. And if they're not in your possession, that's not an excuse. You need to tell the other side where the information is. You've got to produce your insurance policies. That's generally in tort cases, but in construction cases, if you all don't already do it, I would think bonding or any other kind of indemnity agreement you have with anyone that would satisfy a judgment need to be produced at the onset of the case. Then you also have to, this applies to all the cases, make a computation of each category of damages claimed by the disclosing party. So that would mean even if you have a counterclaim and you're seeking damages, you need to make this computation at the initial part of the case and provide a copy of the documents or other evidentiary material, unless privileged or protected from disclosure, on which each computation is based, including materials bearing on the nature and extent of injury suffered. Again, provided the party's not supposed to provide non-economic, well, that would be only in court cases. But take a look at what that means if you're the plaintiff's lawyer, especially. You better have your ducks in a row if you're in a 20-story condominium defect case, and you're making damage claims on behalf of the owner or the general contractor who hadn't been paid. You better be ready to produce a computation of damages at the onset of the case. And if you don't at the onset of the case, again, you take a real good chance that the judge later is going to strike that area of damages because you did not provide it at the initial phases of discovery. I'm not going to skip past that one. That's pretty much something we've always done. And I'm going to talk to you about trial continuances in a second. Okay, time for initial discovery disclosures. The party must make the initial discovery disclosures that I just referred to, required by this rule, within 60 days after service of the complaint. So that means if you're the defendant getting served, you've got to make this disclosure within 60 days, and the plaintiff likewise has to make the disclosure within 60 days after the complaint's been served by him or her on your client. 60 days, all of those things before. Witnesses, ESI, written discovery, whatever it is that you're going to be using that you normally would take, most of you lawyers, 2 years to put together, you better be ready to do it in 60 days. Okay, unacceptable excuses and objections. These are all out the window too. All of these, I object to this and I object to that. If you're doing it in my division, I'm telling you right now, I may give people a little bit of a window, but you're going to pay the other side attorney's fees every time you do this without good cause. It says the party must make an initial discovery disclosure based on the information then reasonably available to you. A party is not excused from making its discovery disclosures because they have not investigated fully the case. What's that mean? Or because challenges to the sufficiency of the other party's initial discovery disclosures are inadequate because the party has not made initial discovery disclosure. So if the plaintiff sues you and they don't make the 60-day disclosure that they're required to do, and you get sued, you can't say, I never got any of their disclosure, Judge. The judge, I never had a chance to fully investigate my case. You independently are being held under these rules to do what you're required to do and not object based on what the other party did or did not do. The party who formally objects to providing certain information is not excused from making all other initial discovery disclosures required by this rule. I see that a lot, where the lawyer will pick and choose 5 or 6 objections in a 20 request to produce and say, well, since I objected to those, I'm not giving the others either. I'm telling you all, I don't like to say it, but if you all don't get on board with these rules quickly, you run the risk that you're going to be sued for legal malpractice if the judge sanctions you in some way for failing to comply with the rules. You run the risk that a witness, some evidence, some pleading, something critical to your case may be stricken by the judge because of late disclosure. And I have to tell you, when I read these things and I see what the offended party may argue by writ or on appeal, the fourth district's going to look at the rule just like I'm looking at them. Say, what the rules say? What did you do? Why didn't you do it? The judge isn't really kind of like we are now, where we say, well, what are your 11 excuses why you didn't do this? We're now looking at what did the rules say? Why didn't you do it? If there is a valid reason. And if there's not a valid reason, something unfriendly is going to happen to you or your client. I don't know if it's going to affect the lawyer, or it's going to affect the client, or it's going to affect both. Party who formally objects to providing certain information is not excused from making all other initial discovery disclosures under this rule. Supplementing of discovery, another big change. In the old rule, the party who has responded to a request for discovery with a response that was complete when it was made is under no duty to supplement the response. New rule, party who's made a disclosure under this rule or who has responded to an interrogatory request for production or request for admission must, not voluntary, must supplement or correct its disclosure or response in a timely manner if the party learns that in some material respect the disclosure or response is incomplete or incorrect, and if the additional or corrective information has not otherwise been made known to the other parties during the discovery process or in writing. Or the only escape from this is an order from court. Old rule, another big one. When it issues setting cases for trial, we all live by this for the last 40 years. You couldn't set the case for trial as the judge till 20 days after service of the last pleading. New rule, the failure of the pleading to be closed will not preclude the court from setting a case for trial. So I've pretty much been doing that in complex business because the complex business rules allow us to do that. But now this is across the board, all cases. So if you're at some motion and you're just telling the judge, Judge, I got a motion to dismiss on this. You can't set the case for trial. He should completely ignore you and set the case for trial. It's not the judge's fault. These are what the rules say. Look at this one. Motions, this is Mr. Kohlenberg's least favorite in the whole list based on his motion practice. Motions to continue trials are disfavored and should rarely be granted, and then only upon good cause. Successive continuances are highly disfavored. Lack of due diligence preparing for trial is not grounds to continue a case. So what's that mean? Oh, judge, we haven't taken their expert. Oh, judge, I haven't disclosed my expert. Oh, judge, my expert got conflicted out, and now I get a new expert. None of those are grounds for continuance under the new rule. Motion requirements. Motion to continue trial must be in writing. I think a lot of us have ignored this. It is now going to be strictly enforced. It has to be in writing unless it's made at trial. And it must be signed by the named party requesting the continuance. That means your client. We've had that rule in effect probably for 20 years, and I think probably 90% of the time, the lawyers just file a motion and don't have the party requesting the continuance sign off on it. Must be filed promptly after the appearance of good cause to support the motion. Failure to promptly request a continuance may be a basis for denying the motion to continue. That's another one that I see with some regularity. Okay, now, all motions now for continuance need to state the basis of the need for the continuance, including when the basis became known to the movant. When did you learn about this? Whether the motion is opposed, the proposed date for which the case will be ready for trial, and whether that date is agreed to by all parties. So all motions for continuance now have to have those three things. In ruling on a motion to continue, the court must state, which we've never had to do before, either on the record or in a written order, the factual basis for the ruling. In order granting a motion to continue must either set a new trial period or a new case management conference. If the trial is continued, the trial must set forth the earliest date practical. The order must reflect what further activity will or will not be permitted. So I'm going to continue your case, but if there's not things in there that you say you need me to allow you to do, then I'm in error as the judge because I'm required to set forth the things you'll be able to do during the next time the case is set for trial. And it doesn't mean that we just open up discovery for you all to do everything else you want to do. It needs to be in the order. Okay, these are highlights of this. And I'm going to go to our AO in just a moment. I want you to look at these numbers here. I've shown these numbers in other lectures. Civil pending cases in 2019. And I was admin judge before I was chief judge. So these numbers are pretty consistent as of 2019. It's always been around 33,000 cases. So in 2020, In March, COVID hit, and we stayed pretty much the same during the 2020 year. And astonishingly, by the end of 2021, and we didn't reopen the courthouse until July of 2021 from COVID, our case counts went down 4,000 cases, which is really extraordinary, and much to do about the hard work of our circuit court judges. Then in 22, we went down another 6,000 cases, almost 6,000 cases. And between 22 and 23, the end of 23, we were right at 23,000 cases. Now, some of you may have forgotten because you don't do tort. In March of 23, when the legislature enacted all these new tort reform bills, we assimilated 8,000 new filings just in that 1 month alone. So we had 8,000 new cases in circuit civil in March or April of 2022, 23 it was. So that left us basically between those 2 years of whatever our current case count was, plus another 8,000. And still, by the end of 23, we were at 23,000 cases. And when I did this PowerPoint a few months ago, circuit civil case count was 18,904. So we almost cut our cases in half over a period of 5 years, 1.5 of which we were in COVID. So you ask yourself, well, Judge Tuter, Mr. Chief Judge, why in the world are we changing the rules of civil procedure if we've been able to abolish our case counts to historically low numbers? We've never been as low as we are right now. And it's all because of my colleagues' hard work in handling civil cases. All right, quickly, I wanted to go over this new 15-page case management order. What I am going to do here is I'm going to post this brief discussion together with our the new trial order that we're going to be using this year and the new case management order that we've handed out to some of you in the courtroom. So for some of you on Zoom, if you go to my practice procedures page and scroll down to the bottom, these orders will all be there. And I will also post this brief PowerPoint for anybody else to discuss. So if you start off on the first page, you again look at scheduling of a mandatory case management conference. I think if I were asked if this new change orders, case management orders, favor one side or the other, I would say clearly, unequivocally, without a doubt, they favor the people who are filing the lawsuits, the plaintiffs. Why? Because the plaintiffs get to get everything in order before they file a lawsuit. They know who other witnesses are. They better take statements. They know what their discovery is going to be. They know what their damages are. So all of that, they get to file a lawsuit, and then within 60 days thereafter they serve folks, disclose all of this information. The days of holding back stuff and holding back evidence and trying to be cute, as some lawyers have become over the years, those days are gone. You can try and do that, but if you get caught, nobody's going to have any sympathy for you being caught. Not the appellate court, not the Supreme Court, certainly not the trial judge. So I think we have completely switched the way we should handle these cases from lawyer-driven to court-driven. So everything you say in your mind that you're calculating, what should I give them and what should I not give them, you better be doing the analysis of, well, if I'm Judge Tuter, what would Judge Tuter say? Or if I'm Judge Levinson, what would Judge Levinson say? Because that's the perspective that this is going to be looked at, not necessarily from the lawyer's perspective, but the compliance with this order perspective. So if you see right on the CMO, the first sentence is the deadlines must be strictly enforced. Keep in mind this order is effective for all cases filed after January 1st, 2025. That also creates another bit of a dilemma for trial judges. We've now got to manage cases that are under the old kind of case management orders that we ran, and now I've got to manage them under new case management rules. it's going to take us a little while to adapt. So if you look at the first sentence for complex business cases, not complex cases, but complex business, I have 30 months to set the case for trial. I've had cases where I've barely been able to get the case with everybody served and filing a response within 20 months or 25 months. And here I am, I've got to have the case over with in 30 months according to these rules. The scheduling of a mandatory case management conference now is a really big deal, as you'll see from these orders. After everybody's been served, 60 days, no later than 60 days after everybody's been served, the plaintiff's lawyer has scheduled a mandatory case management conference. I don't know what to say about that in construction cases, in cases where I have 17 or 18 parties, and you guys are outside squabbling about, well, this one's gone here, and that one's gone here, and this one didn't go there. I think what I'm going to end up doing is telling the plaintiff's lawyer, you said it. If they don't attend, they don't attend, and you can get your pleading straight. So you need to find somebody to attend for you, or find a way to get on the phone for 30 minutes and do it yourself, or some other way to try to get in on the initial case management conference. Counsel for the plaintiff shall set this mandatory conference no later than 60 days after service in all parties. But here's what you're required to do 20 days prior to the date of the mandatory case management conference. Take a look at that. 60 days to set the conference. And then 20 days before the conference occurs, which is a very short window of time, you're supposed to meet, confer, and prepare a joint statement, which must be filed with the clerk 14 days prior to the mandatory conference. Look at those 3 dates. Some of you guys can't do anything in 14 days, but these rules are going to require you to do it. And look at all the things you've got to do at the onset of these cases. I'll skip through them without reading them all. You've got to go through pretrial management of a large number of witnesses, propose limits on joining other parties, filing and hearing motions, identifying non-parties, names of attorneys responsible for handling the case, necessity for protective orders. Just go through that list there on page 2. It's A through F, A through P, excuse me. So all of those things at the initial mandatory case management conference have to be discussed, and that has to get on a piece of paper for me to review when we hold the mandatory case management conference. At the initial case management, the court trial date period no sooner than 6 days and no later than 30 months from the date of the conference will be set. And again, there's the rule. Should rarely be granted if you're asking for a continuance in a complex case. So if you only had 2 parties that were both served, and you both had to do all this stuff within 60 days, and you had a mandatory conference within 60 days, within 2 months of that case, you all are going to, let me see if I can keep up here. You all are going to have to give me a date that you're ready for trial. And so I see what everybody's going to do before I even have a whole hearing. Everybody's going to want 30 months. And it may be that that's where I go with this, to give you 2 years to get the case ready. And look at the other one on that page. During the case management conference, the court may elect to hear any pending motion, even if the parties have not identified the motion as an issue to be resolved. So that excludes motion for summary judgment and evidence hearings. But all you lollygaggers who just file that initial motion to dismiss and do nothing with it, don't set it. I promise you most of the judges are going to call those up for a hearing at the case management conference and rule on it, whether you're ready or not. So you need to be ready for everything that's gone to date in the docket when you have this initial case management conference with the judge. Also, I'm not sure if this was under the old rules or if this is new. I don't think it's new, but 120 days, upon service of the complaint, on the last of all named defendants, the plaintiff needs to file a notice of service indicating that everybody has now been served in the case. All right, and then at the bottom of that page, initial discovery disclosures, it's going to set forth the same things I talked to you about within 60 days after service of the complaint, unless a different date is chosen by me. And then if you look on the next page under little i's, these are the things that initially must be provided. I don't envy the construction lawyers who have a construction with a bad hotel, so to speak, and they're suing, I don't know, 15 different defendants. And in the initial disclosure, they got to name all the witnesses, they got to name all the documents, they got to name everybody who has information about the so-called failures in the initial discovery to the parties in the case. Many of the plaintiff's lawyers have experts that they've retained long before they filed the lawsuit. So in some way, maybe filing or providing their expert report with comments specific to the particular client involved may satisfy much of this discovery. But it's definitely a rule changer for those who want to be procrastinators and wait till the very end to provide this information. Again, in the CMO, we point out that on page 5, that these disclosure deadlines require they be supplemented. And then another difficult deadline, I think, to meet is paragraph 8 says 15 days after the initial mandatory case management conference, the court must enter a case management order. It's barely 2 weeks. Parties are directed to prepare a proposed case management order, which must address each matter set forth in the rule. And the case management order also must specify the following. And then you go on to the requirements, expert witness requirements in Rule 1.280. Those all have to be in the initial case management. And I'll tell you one thing I'm not going to do. I can tell you right now, maybe because you all have worn me down here in 10 years in complex business. I'm not going to adjudicate 2 different case management orders. One side gives me a case management order with 15 things. Another side gives me a case management order with 15 other things and says, hey, Judge, here's the transcript you figured out. I'm not going to do that. So we're going to have to, I guess the judge is going to have to make these specific findings on the record during the conference so that there's no dispute about it later. Okay, and then if you look at paragraph 2 there, this is another one on naming witnesses, expert witnesses, which is a troublesome thing in all cases because you don't often know who you're going to disclose and what their information might be. Some very specific rule-oriented things, including with a disclosure, giving 3 confirmed dates for the expert witness to be disclosed. And if you don't choose one of those 3, I don't know what you're going to do, because I'm not very good at refereeing discovery dates between lawyers. The other thing this rule requires in many places is meet and confer. It's no longer just file something and don't talk to the other side about it. You are obligated to meet and confer to discuss things like motion calendar, continuances, evidentiary hearing dates, all of these things that we normally would just kind of, you guys might send a text to each other and say, that's what I'm doing. These rules now require meet and confer sessions. So you better keep that in mind. Now, if you scroll down to the bottom of page 6, beginning 6 and going on to 7, we put out some event dates and some disclosure, some completion dates. So you can use these dates if you so choose, or you can choose another date in my division, but all of them have to comply with the final disclosure dates prior to the case being called for trial. So whatever that trial date was that you get in the initial case management conference, these dates are going to be consistent with that date. And if you go through these dates, These are specific dates for expert and disclosure dates for expert and fact witnesses. We do that now, but again, much of that is largely ignored by you all. It won't be largely ignored. If you look at 12, paragraph 12, conferral prior to filing motions even, or filing a non-dispositive motion. That's any kind of motion except for summary judgment or judgment on the pleadings. The movement must, capital letters, confer with the opposing party in a good faith effort to resolve the issues raised in the motion, and at the end of the motion, above the signature block, put in that we have conferred, or I have conferred and attempted to resolve the matter. This is a rule that's been in effect for some time. Now it is a mandatory rule, and before you even file your motion with the clerk, you need to be able to state that you made that conferral process with the other side. Another big one for you lawyers in these complex cases is paragraph B1, no later than, in this case, 120 days prior to counter call. Motions to add parties or amend the pleadings need to be completed. That seems to be in perpetuity in complex business, where people add parties and file third-party complaints right on the eve of trial. The other problem with this order and these rules are for people in business cases, especially, or construction cases particularly, where somebody doesn't really know about the existence of a third party until they get into the discovery, find out what their involvement on the job site was, find out they're really the guilty party of this, and then they file a motion to amend to add that third party, and the third party gets in the case, and guess what? The third party's got 45 days to prepare their case for trial because no continuances should be granted. So what do you do with a third party defendant in a case like that? It's problemsome. And I think you lawyers also, you complex business lawyers especially, need to be particularly careful about what cases you take if the case is set for trial or the case is on an eve of trial, unless you're a golf course buddies with a judge and can guarantee a continuance, which none of you would be. You're going to be under the gun because the judges might well say, sorry, I'm not giving you a continuance. Now he may sever that third party defendant out, but if he chooses not to, you're going to trial with whatever evidence you have, whatever you disclosed to date. It's another part of these rules that I don't think was very well thought out when they did these rules. All right, motions in limine, as far as I'm concerned, they should abolish that. I hardly ever hear those, and I usually look at them on paper before I make a motion, before I make a decision. Joint pretrial stipulations. I hear this perpetually from my colleagues in the other divisions where lawyers have not prepared pretrial stipulations and they're on a trial docket and they're getting ready to be called for trial. The judge pulls the case up and there's no pretrial stipulation. This rule now requires a joint pretrial stipulation. And going back to what I said about the 4th district, if you didn't file a joint pretrial stipulation in the case, one side or the other, maybe one side filed a unilateral, there's really no excuse for it, because any joint pretrial stipulation, in my division at least, you can put all the issues there, and you may have a divide on what the plaintiff or the defendant says. You put what the divide is and let the judge sort it out later. But just not doing one is really reprehensible. And I think those of you all who aren't doing them, and can I speak to all you folks online who might be in water loss cases? If you don't do a joint pretrial stipulation, or you don't do some form of a joint stipulation prior to trial, you run the risk that the court may dismiss the entire case based on non-compliance with the rules. And then it sets out right there, we do in paragraph, page 11, right on B, all of the things your joint pretrial stip must have. So it's all right there for you. All you got to do is follow this form. Paragraph B, 14, court rules. The requirements of this order cannot be waived by stipulation absent prior approval from the court. So even if you and your other side against farm rate, you stipulate to something like a continuance, judges like to tell you no, it doesn't comply with the rules. Not because the judge wants to be unreasonable, because the judge is following what the Supreme Court tells him he's supposed to do. But I make a Monday more dreary than this. I didn't write these rules, guys. And then there's a whole category on page 13 to 14 where no continuances will be granted, more than I've ever seen before. The rest of this has primarily been in the rules that you all have been dealing with for so many years.